but we got some very good news today. Before we talk about the significance of this, I want to remind you how we got here. We had a Travis County District Attorney who was stopped by police, who was visibly intoxicated, who had an open bottle of vodka on her front seat, who had been driving the wrong way down the highway, who was aggressive and abusive to the arresting officers, who was aggressive and abusive to the individuals who were trying to process her, they had to even go so far as to place a spit mask over her face. This is how we got here. Governor Perry rightfully vetoed the funding over the department that she was in charge of, and even though she went in front of a grand jury for her abusive behavior, the grand jury did not indict in Travis County, but the grand jury indicted the governor for the veto. That's how we got here. Today we had a ruling from the Third Court of Appeals, and it's a step forward, a victory for the rule of law. One down, one to go. The Americans in this country are looking for a president who will stand up and do what's right, and that's exactly what Governor Perry did. The court today threw out what we believe to be the greater of the two charges, that is, the coercion charge. The remaining count we believe to be a Class C misdemeanor, and we think that count is hanging by a thread. And understand, a Class C misdemeanor, we're talking about a traffic violation. And it's unfortunate that the prosecutor pursuing this case has already charged Travis County 4 times what a misdemeanor prosecutor makes in a year. The appeals court made it clear that this case was very questionable, but unfortunately they felt like it was too soon to throw out the remaining charge. But we believe once we put that issue in front of the Court of Criminal Appeals, they will throw it out on its face, and Governor Perry can go about his business. Anyone who's seen the video of that drunk DA will know that Governor Perry did the right thing. This will have no impact whatsoever on his presidential campaign. I'll take 2 questions.
So you are appealing the as-applied challenge?
The Court of Appeals, the way I read the opinion, it's a 97-page opinion, made it very clear that but for legal precedent, they would throw that charge as well. We think the Court of Criminal Appeals will look at that and realize that, in fact, Governor Perry and the legal team is right on that.
How long do you expect it to take the Court of Criminal Appeals to address the second charge?
I've never predict what a court and how long they're going to take. I hope they will act as soon as possible because, I mean, this is not a matter of if this will be dismissed, but when. That's all. Thank you.